morning. My name is Nick Campins. I'm here today to testify on behalf of the California Department of Justice, the Office of the Attorney General. I want to talk a little bit about the importance of streamlining the defense to repayment. I'm the lead Deputy Attorney General assigned to my office's case against Corinthian colleges and its subsidiaries that operated Heald, Everest, and Wyotech. As that litigation demonstrates, providing debt relief to students in cases involving alleged state violations is the appropriate and the just action to take in the face of widespread allegations of misconduct. We allege, among other things, that Corinthian misrepresented job placement rates. They advertised for programs that they did not even offer. For example, advertising for ultrasound and X-ray tech programs that were not even in their catalogs. They unlawfully used official United States military seals in advertising, and that they misrepresented the transferability of credits. These alleged misrepresentations go to the very core of someone's decision to attend college. This education that they were promised was for a very steep price. For example, at Heald College here in San Francisco, they charged $39,510 in tuition and fees and $3,500 in books and supplies for an Associate of Applied Science degree and medical assistant. These students who attended the schools were from a very vulnerable population. As we allege in paragraph 3 of our complaint, they were near the federal poverty line. They were also, according to internal company documents, targeted because they were isolated, inpatient individuals with low self-esteem, who have few people in their lives who care about them, and who are stuck and unable to see and plan well for their future. The department needs to develop simplified and streamlined procedures to help vulnerable students who have been the victims of unlawful activity, and it needs to do so on an urgent basis. That is why we strongly support the department's simplified and streamlined procedures to help vulnerable students who have been victims of unlawful activity, and we believe that the Attorney Generals should be represented as negotiators and should play an important role in the negotiations. I next want to talk a little bit about the critical role that is played by the Attorney Generals in this space. While AGs are not the primary regulator, we are in a position to respond to and investigate the most egregious cases. The department's streamlined approach to the adjudication of many Heald students' claims demonstrates the power and efficiency of looking to prove wrongdoing on a systematic basis and working together with AGs. Our office was the first to bring litigation against Heald in October 2013, and our investigation served as a first salvo and would ultimately prove to be historic action by the regulatory community, including the Department of Education. As that matter demonstrates, AGs can and will provide evidence and material support to the department in adjudicating wrongdoing. AGs have practical experience in understanding the interplay between defense to repayment and state law violations, and we have concrete ideas about how the process might be streamlined. AGs understand false advertising, we understand unfair competition laws and how they apply to for-profit schools, experience and knowledge that will prove invaluable in the negotiations. Our office has leveraged this awareness to lead an unprecedented effort to assist students, including a dedicated website, interactive tool, and collaboration with legal aid organizations to help secure legal advice and assistance. In fact, more than 12,000 students have visited our website, and nearly 5,500 of those students have completed our online interactive tool. Again, AG's offices should be included in the negotiations as negotiators. The AG community is already very engaged in this issue. The Attorney Generals of Massachusetts, California, Connecticut, Illinois, Kentucky, Maryland, New Mexico, New York, Oregon, Pennsylvania, and Washington State, and others all plan to submit a joint written comment concerning this proposed rulemaking. As noted, the current decisive factors in the defense to repayment are proof of a state law violation, which we are, by definition, in a great position to opine on. We understand what it takes to prove a case and how difficult it can be for individual students to do so in the context of well-financed schools and in the limited legal recourse given to them, given the proliferation of arbitration clauses in enrollment agreements. We also bring a unique perspective. We understand both the interests of protecting students and the interests of regulators and the government. AGs have been in this space for decades, and we have the breadth and depth of experience necessary to understand these issues and contribute meaningfully to the negotiated rulemaking. We hope that you will have AG office negotiators on the committee. Thank you very much.
Yeah.